reporting to you from DC here, my friend. We are talking about removal proceedings, and we have been talking about a series that we started yesterday, and we're continuing with the series about removal proceedings, deportation orders, and order of supervisions. We're going to talk about appeals. We're going to talk about anything related to removal proceedings because we are living under uncertain time. We want to provide guidance and clarity to all of your questions. My name is Bijoux Ngwanda, your immigration lawyer here in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, please go ahead and like, share. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Today we're talking about adjustment of status to marriage in removal proceedings. Can I adjust status to marriage in removal proceedings? The answer is simple: yes, provided that you can prove that it is a bona fide marriage. Marriage in question was entered in good faith, not for the purpose of evading immigration laws. Why is it important for a person to be able to prove that? Why? Because once a person has been placed in removal proceedings, then they get married after being placed in removal proceedings, the presumption is that the person has committed fraud. It is law, that's what it is, okay? The burden now shifts very high on that person in order for that person to prove that they did not in fact commit fraud. It was a valid marriage, entered in good faith, not for the purpose of evading immigration laws. As a matter of fact, the petitioner has to sign some paperwork, okay? It's called the waiver. They have to sign some paperwork stating some type of law, stating that this marriage is a good faith marriage, not enter for the purpose of evading immigration laws. They have to sign it. This is just how the law is, and that's a requirement, okay? So if a person is placed in removal proceedings, they want to get married, we are here to help, but we have to guide you through the process so that you can show to the immigration judge that this marriage is valid, not enter in for the purpose of evading immigration laws. Now the question becomes, should I terminate my removal proceedings because I got married? How does it actually work in reality? Sorry. In reality, the way it works is this. You get placed in removal proceedings. You have been issued a notice to appear. You have to appear in court. You have a date, and that's your master hearing. On the day of your master hearing, you enter your pleadings. Then they ask you about your defense. First of all, you have to look at we've talked about it. You have to refer back to my previous videos. We talked about how you have to make sure that the allegations on the notice to appear are in fact correct. If they're not correct, you have to deny it so you can preserve your rights for further adjudication. But, you know, we talked about that before. I'm not going to repeat myself here. But anyway, you tell the judge, the immigration judge, that my defense is adjustment of status based on marriage. And the way it works, you file I-130 with USCIS. Once I-130 is approved, then you come back to court to terminate removal proceedings. Either, in alternative, adjust in court. Nowadays, when you ask them to terminate removal proceeding, you really have to show them that you are going to adjust status. You are, in fact, prima facie eligible to adjust status. That you enter with inspection. If you did not enter with inspection, that you were, in fact, parole. visa is immediately available, and the petitioner meets the sponsorship requirement. You show them evidence. You just don't cite it. You show them evidence. This is how you get the judge to terminate removal proceedings, okay? And once they terminate it, you can go back to USCIS and adjust status with USCIS. And the reason we want you to go back to USCIS because adjustment of status in court, the standard is very high. Then you have questions from everybody. Immigration judge, ICE counsel, your personal counsel, and it can be a little bit intimidating. That's why we advise people to go in affirmative way to USCIS, especially if you have the ability to terminate removal proceeding. It's better for you to adjust status with USCIS. Why? Because over there it's not hostile, as long as you can prove it's a bona fide marriage and the petitioner has signed some paperwork to show that the waiver, to show that really this marriage in question was entered in good faith. And this is the context we're talking about when a person got married after being placed in removal proceedings, right? That's when the waiver come into play. But anyway, if you're in court, sometimes the ICE counsel, it has happened to one of our clients before, that was even under Biden. ICE counsel will ask us to file for a waiver of fraud. Why? Just because the person got married after being placed in removal proceedings. But again, there's a way to make sure that when you're filing a waiver for fraud, you're just really not admitting to fraud, but perhaps to misrepresentation, if any is in it, right? But we have seen it before as a requirement. As a matter of fact, even the judge ordered us to pay for the form I-601. Why? Because the person got married after being placed in removal proceedings. And that, again, is the reason why we suggest that you go back to USCIS if you can. And in order for the court to terminate, you really have to show them evidence that, in fact, you meet the eligibility requirement to adjust status under 245A. Okay? We are here to help. If you have additional questions, please comment below. If you need a consultation with me, you can schedule it anytime by using the consultation link in the description box below. We're coming to you here from DC, and we have a series of immigration removal proceedings videos. Until next time, bye.